everyone, and welcome to this evening's session. Tonight we will be discussing the 1997-1999 Cherokee Constitutional Crisis. I'm your moderator, Kimberly Gilliland. We'd like to thank all of the Cherokee Pens Project volunteers that have graciously agreed to participate this evening, and Star University's Department of Tribal Governance and Administration. Star University is an international university that will be launching online degree programs and certificate programs in the fall of 2018. This spring, Star will partner with the Cherokee Pens Project to offer a certificate in Cherokee Government and Society. For more information, please contact Star at info@staruniversity.org or visit the website at staruniversity.org. Tonight's presentation is an open discussion, and we will answer questions throughout the presentation. Please submit questions in writing via the chat box you see in the lower right corner. At this time, I'd like to introduce today's presenters. Julia Coates is a citizen of the Cherokee Nation, born in Pryor, Oklahoma, and raised in Northern California. She holds BAs in Anthropology and English from San Francisco State University and a PhD in American Studies from the University of New Mexico. Dr. Coates was a delegate to the Cherokee National Constitutional Convention, was the project director for the award-winning Cherokee Nation History course, and served 2 terms on the Cherokee Nation Tribal Council. Also joining us are Cherokee Nation citizens Paula and Pat Ragsdale. Mrs. Ragsdale served as a tribal council member during the constitutional crisis, and Mr. Ragsdale served as the head of the Marshal Service. Welcome.
What I'd like to do, first of all, with everyone, if you were with us on the first webinar, you know that I took us up to the 1975 Constitution, and I want to review just a few aspects of that Constitution that became pertinent when this constitutional crisis, as it's been called, erupted in 1997. So there are some articles here about the legislative branch. These come directly from the 75 Constitution. And I just want to call your attention to a couple of lines in here. First of all, that no business shall be conducted. I'm going to have to collapse my screen here because I can't read it. No business shall be conducted by the council unless at least 2/3 of the members thereof, regularly elected and qualified, shall be in attendance, which number shall constitute a quorum. So remember that 2/3 of the tribal council must be present at a meeting in order to have a quorum. And in 1997, when there were 15 people on the tribal council, the 2/3 was 10. 10 people had to be in attendance at a meeting before it was a legal meeting. In section 5, this also says that any special meeting of the council can be called by the principal chief, the deputy principal chief, etc. But it also says the purposes of the meeting must be stated in a notice published not less than 10 days prior to the meeting, and that whatever is on that agenda is the only thing that the council can consider at that meeting. So that became relevant as well. Okay, we can go to the next slide. What the council does, they are the legislative branch, and so they have the power to establish laws, and that the laws that they pass, however, cannot be contrary to the provisions of the 1975 Constitution or to whatever Constitution it is. And then the next article has to do with the executive branch. And it says that the principal chief can convene special meetings, but again, that the purposes of those meetings must be stated and that those are the only things that can be considered during those special meetings. Next. This is just a general, this is the only paragraph that exists in the 1975 Constitution regarding the judicial branch of the Cherokee Nation. And it's just interesting because in the next webinar from 1999, we will look at the 99 Constitution, and next time you'll see how much more this was elaborated. I think because as a result of this crisis, it became apparent that we needed to have much more specificity about the judicial branch in particular. Next. The legislative branch, it says the council shall provide by law for an annual expenditure of funds. So it's often stated that the legislative branch is the branch that holds the purse strings. And throughout this section on fiscal matters, you see that over and over and over, and you see the process that the administration, the secretary treasurer has to go through, reports, budgets, monthly reports, statements of where revenues come from, all of that has to be provided to the council on a monthly basis and an annual budget. And so that is something to remember as we talk about this constitutional crisis. Next. Any laws authorizing the expenditures of money by and on behalf of the Cherokee Nation have to be passed, approved by the council. And the council only authorizes the purposes for which money is to be used. And so that is something that's important in regard to this constitutional crisis. And then the last thing we want to look at here is the removal from office. In the 1975 Constitution, this is the totality of Article 11. This is it in terms of how an elected official can be removed from office. And I think it became apparent that this was not sufficient. And so one of the things that we saw in 1999 was, again, much more elaboration about exactly how this takes place. So with this quick perusal of the 1975 Constitution, we'll go next into sort of setting up the circumstances in the next slide. Oh, I'm sorry, there's a little bit more employee rights, okay, that employees cannot be removed except for cause, and that they will be afforded a hearing by the Judicial Appeals Tribunal. And then, as I said, what is not in the 1975 Constitution, right? The process for removal and impeachment procedures. Okay. So to set up the 1997 events, what we remember, many of us remember, and if you're new to these events in recent history, in the 1995 election for principal chief, there were multiple candidates that ran for office. And because of that, no single candidate got more than 50% of the vote. So we went to a runoff at that point. And the runoff, the top two candidates were George Bearpaw and Joe Byrd. And so they were going to face each other in a runoff in July of that year. Chief Mankiller, who was leaving office at that time, had given her endorsement to George Bearpaw, who had been a tribal administrator in her administration, over Joe Byrd, who had been and was on the tribal council previous to that time. I just want to state that these are more recent pictures of these two individuals. This is not what they looked like in 1995, but it is what they look like more recently. Next. And in the interim between the general election and the runoff, it was brought to the attention of the Election Commission, the courts, that George Bearpaw had a prior felony on his record. And in the 1975 Constitution, that makes an individual ineligible to hold elected office. Bearpaw did not feel that he was hiding anything necessarily. The felony had been expunged from his record, and so it was his belief that it no longer counted as a felony. And that was unclear, and so the question was actually brought to the Judicial Appeals Tribunal, which was the name at that time of the Cherokee Nation's highest court. And the JAT ruled that a felony, even one that has been expunged from a person's record, is still a felony. And so they ruled that Bearpaw was ineligible to run, and so that Joe Byrd was now the only candidate in the runoff. Next. At this point, the candidate who had finished third in the general election asked the JAT that he be allowed instead of Bearpaw to enter the runoff, just so that, you know, Byrd had an opponent, because Byrd had not gotten more than 50% of the vote. And so, you know, the feeling was that that he should not run unopposed. That candidate, that third place candidate, was Chad Smith, and he had been the Director of Justice in the Wilma Mankiller administration. But the JAT denied Smith's request to enter the runoff. And so what that meant was that in 1995, Joe Byrd was basically defaulted into the office of principal chief because of these two rulings of the Judicial Appeals Tribunal. There was no opponent, essentially. Next. Okay. So now we head into basically about a year into the Byrd administration in 1996. And at this point, the tribal council had not been receiving financial reports from the administration, particularly I think about information about expenditures on attorneys that had been requested. And so at this moment, I'm going to begin to engage Pat and Paula Ragsdale, particularly at this time, Paula, I think, because Paula, you were on the council at this time. Your name that you would be on record as was Paula Holder. And I was wondering about just how this came about. If you could talk a little bit about what you were and were not receiving, and what the discussion was among the council members as to what to do about it.
Thank you, Julia. Yes, in 95, at the time Chief Byrd took office, August 14, 1995, you know, we're rocking and rolling and normally walk through and get a budget, etc., for expenditures for any administration, new or old. We, as a council, the council did not receive any budgets, but expenditures continued. We addressed the matter. We requested, you know, what does the budget look like? Are you getting ready to propose one? He was new. He asked for more time. So we started passing continuing resolution, individual expenditures, etc. But unclear of where the money was being spent. December of that year in 95, we gathered as a body and requested the principal chief submit a budget for the fiscal year so that we could pass expenditures for the nation. The principal chief at that point in time told us in December of 1995 that the Constitution, you know, we told him it was constitutional requirement for us to pass expenditures as a body, a legislative body, and he told us at that time that the Constitution was old and we did not go by it anymore. At that point in time, and we had it recorded. It was in a committee meeting. It was, you know, full body of the legislative branch. We were, needless to say, in shock. And at that time, we knew we were on shaky grounds and things needed to be addressed, maybe in a more serious matter. And that's when in January of 96, we took the matter to court, questioning expenditures, etc. And focused a lot on attorney fees because a lot of attorney fees were walking out the door.
Yeah, the bottom line is the administration was basically stonewalling reporting on the expenditure of tribal and federal funds for various programs, in particular the outside attorneys that became the main part of the controversy.
That is absolutely mind-blowing. That reminds me of a remark that President George W. Bush made during his administration, that because those treaties were old, they were no longer in effect, right? That is just amazing. there were some other things I think that were going on in the summer of 1996 that were around the director of the Housing Authority, Joel Thompson. And I think he ultimately went to prison for about 10 years or something like that, or that was his. I'm not remembering too much about that, but Pat, maybe do you remember specifically what that was about and what Chief Bird's actions were in regard to that?
I'm sorry, Julia, I couldn't understand your question. I had a lot of noise in the speaker. I didn't understand you.
The question was about, this was also happening in the summer of 1996, was the director of the Housing Authority, Joel Thompson, was getting into some trouble as well, some legal trouble, and he was actually convicted in federal court and I think served about 10 years. Do you recall much about what that was about?
She said something about federal court in the summer of '96. I'm sorry, I cannot understand.
Okay, I'll try and type it in, but
okay. Maybe that'll help. Not 96.
I think while we're waiting for that, maybe I'll go ahead with some of these. Yes. Joel Thompson.
Yeah.
Okay, that's my deal.
Okay, yeah, that was some of Pat's law enforcement stuff.
Yeah, there became a controversy that, there were a lot of different things that were going on all at the same time. There became a controversy about the involvement of the Housing Authority Director, Joel Thompson, in the election campaign of Joe Byrd. And it finally ended up after a long period of time. I started an investigation. The administration ordered me to stop the investigation for various reasons. I finally agreed that I would turn it over to the United States Attorney, which I did, and they subsequently, after about a year and a half, indicted Mr. Thompson on about 16 or 17 different federal charges for diversion of funds and I can't remember the specific charges now, laundering money through various accounts. That was the first specific issue that all of us started to begin to realize that we had an administration that they thought were above the law. And that could have been settled in tribal court, but ultimately was settled in federal court because they found that the circumstances warranted a federal indictment, and Mr. Thompson was indicted and convicted and served federal time.
So I think that's exactly correct. Just being aware by the summer of 1996 that there were a number of financial irregularities that were beginning to be suspected. So the tribal councilors had petitioned the Judicial Appeals Tribunal to, as Paula said, to provide documents to the tribal council. So I think we can go to the next slide. Okay. So at that time, the tribal prosecutor was Diane Hammonds, and she charged Chief Byrd with misappropriation of funds but throughout the remainder of 1996, Byrd continued to ignore and defy the orders and the tribal prosecutor's charges. And I think that that Paula, you stated this already, that by December of that year, the council was thinking about how to go about, getting some kind of financial records from the chief. So Paula, I don't know if you're able to hear me or if there's still too much static, but anyway.
You're coming across fairly garbled and
Yeah.
and scratchy, but just that it was about this time and it started to culminate that the administration was obfuscating the report on the expenditure of tribal funds. The tribal council was concerned about that and ultimately filed a petition in tribal court before the GAT. The problem is that the tribe had run out of the tribe, I should say, the administration had run out of money to pay the attorneys, the outside attorneys that they were paying, and had been advised by what we now call the Attorney General's office that there was not an appropriation to pay those funds, and so therefore they could not be paid legally. Well, they got rid of the council that issued that opinion to them, and had diverted federal funds over into the tribal funds, which became the center of our focus of the Marshals investigation for the misuse of tribal and federal funds.
And I just realized that on this slide, I put Tribal Prosecutor Diane Hammonds, now known as Diane Hammonds. That should be Tribal Prosecutor Diane Blaylock. That was what she was known as at that time. And so as we go through the rest of the slides, anytime you see Blaylock, that's who it's referring to. Yeah, go ahead and go to the next one. That's fine. Okay. So Diane Blaylock asked the Chief Justice.
Quickly.
Yes.
Let me just add this. Sometime later on, the federal government, through the Inspector General's office, confirmed that about $100,000 of federal funds were misused, and the tribe had to pay those back to the federal government, along with some other funds that were misused.
Okay. So as we go through the rest of this, this is just going month by month. This is following a really excellent chronology that that Dan Agent, who was the director of the Public Relations Office, I think, and he was the editor as well of the Cherokee Phoenix. And so this is a really excellent chronology that he's put together. And if we can go back to the previous slide here for February. Yes, this one. So we get the beginning of this, when it all starts to really become inflamed, is when the Tribal Council has asked the JAT, the Judicial Appeals Tribunal, or Blaylock has, I guess, to issue a search warrant for the chief's office so that financial records can be retrieved, and that that warrant was served by Pat, who's on the webinar with us. So Pat, if you can hear me through the garble, can you just talk about this, all of the things that are on the screen basically at this time? This was a very, very intense moment when everything kind of began to blow up. And if you can talk about that a little bit.
Julia, we lost them. So until I get them back online,
dear.
I'll need you to
Okay. Okay. Well, this is one of the things that I'm really, really hopeful that we can get Pat to talk about a little bit more, because the marshals served the warrant, searched the chief's office, retrieved documents, took those documents out of his office, and by all accounts, this was done in a very orderly and lawful manner. And yet, I think the thing that's striking to me is that whenever I read about this afterwards, this is always sort of styled rhetorically as a raid on the chief's office. So I think it's important to note that this was done by the letter of the law. Every bit of it was. Our court issued the order to our tribal prosecutor. The Marshal Service was used to serve that warrant. Everything was done by the letter of the law. It was done in very quiet fashion. And so as a result of this, to style this as a raid is maybe a huge misnomer. As a result of this, however, Chief Byrd immediately fired Ragsdale and his lieutenant, his next in command, I guess, who was Marshal Sharon Wright. And I would recall your attention back to the Constitution of 1975 under the section on employee rights. And so this would appear to be an illegal firing and something that the chief had no right to do. Do we have Pat and Paula back on now? I think we're getting them back on a different computer. When they were fired by the chief, one of the other justices, Dwight Birdwell. Are we back?
You can talk right now.
Well, we can see them, but they can't see us yet.
Okay.
Pat and Paula, can you hear me? Okay, keep going and we'll try to get back on.
Okay. Justice Birdwell did order that the two marshals be reinstated at that time. And ostensibly they were, although as we go through this, you'll see that maybe wasn't exactly the reality of how it played out on the ground. Pat at that time then brought the FBI and the U.S. attorney into the situation. I think he's talked about Joel Thompson, that he was already involved in that regard. But now we've got a different situation where this is actually involving the chief of the Cherokee Nation. And so the feeling that some assistance was needed as well at that moment. I don't want to go to the next slide until we do get Pat on, because I want him to speak to us a little bit about this era. But I will say, I know that many of the people on the webinar tonight are participants in the at-large satellite groups. And as all of this was happening in 1997, I was involved with one of the early organizations in Albuquerque. And I remember all of this happening, and the leader of that organization, who was the cousin of Wilma Mankiller, actually kind of bringing this to our attention as this was beginning to happen, and how engaged we were as an organization in supporting the marshals ultimately, because many people from the Marshal Service, all of the marshals basically, lost their jobs at this time. There were about 15 of them. And I know that we began raising money and many people did so throughout the Cherokee Nation to help them, because none of them were getting a paycheck for many months through this year. Why don't we go on to the next slide? If we can go ahead and work on getting Pat and Paula on board.
Video settings.
I can see you. And I can hear you.
Now I got two. I have to get two.
Can you hear me?
This right here.
It's not coming through on this one. We lost sound on this one.
Oh, wait.
We can hear you just fine.
Yeah.
Very good.
There we go. Sorry, thank you. You're fine. And wait, her mic just went off.
Sound is great now.
Paula and Pat, the sound is actually very strong now, and we can see you.
Where's the?
Okay, I can
Okay.
How do I turn it up?
We got three computers trying to work.
Yeah, just right
Let me just back.
here.
Can you hear me okay?
Yes, we can hear you just fine.
Thank you.
Okay.
You're welcome.
Coming back to the February 1997 slide that Julia was trying to get us to pick up on, just a couple of details. I did the investigation that uncovered probable cause that tribal and federal funds were being misused. And that's a fairly high standard that you have to meet for obtaining a search warrant. I then took it to the tribal prosecutor, who was Diane Blaylock at the time, and she reviewed it, which is a separate and independent review. She approved of it, and then we then took it to Tina Jordan, who was then the district court judge. Tina read the search warrant, congratulated us for being courageous enough to file it, and then told us that she had to decline to sign it because she had a conflict of interest. She opened up her law book and went to the procedure when the district court judge could not be available to sign a warrant, where you needed to go, and that was to the nearest sitting judge, which happened at the time to be Chief Justice Ralph Keene. Ralph Keene reviewed the warrant independently. He then swore us both in. I signed an affidavit, and he issued the warrant that was carried out the next day as unobtrusively as possible. It was not a raid on the tribal court. We followed normal federal procedure for carrying out a search warrant. We went the extra step of not taking tribal documents from the complex, but rather copying them on the Xerox copier while being reviewed by the then tribal attorney who watched us carry out the search warrant. When the process of filing a search warrant is that once you file it and you obtain the evidence that is required to be obtained under the search warrant, it is returned. It's called a return to the courthouse, and you file a return and file all the exhibits with the court that has jurisdiction over it. That was done, and while we were completing that process, we received a call from the administration, who were very upset that we had carried out a search warrant. And Sharon Wright and I returned to the marshal's office, who were met by the director of personnel and the inspector general that was hired by Chief Byrd. They both told us to stand down, that we were being suspended, and I deferred and told them that we were carrying out an order of the court. It wasn't my order, it was a court's order, and that I wanted the advice of the court on what to do next. I called Justice Birdwell, and Justice Birdwell told me to defer taking any action until I heard from him further. And within an hour or so, we got a court order telling the administration to stand down, that they were in they were suspect of being involved in the obstruction of justice, and that they should stand down. At that point, we were at a standoff with the administration, and I did call the FBI and the U.S. Attorney, asking them to independently investigate the issues at hand. In particular, misuse of tribal funds and or federal funds is a federal offense, in addition to be a tribal offense. And so that's how that day ended.
I know I just typed a question to Kimberly about what was the conflict of interest that Tina Lori Jordan felt that she had. Did she state to you what it was?
No, she didn't.
Okay.
I mean, she was to be fair, she was very gracious to us, did not raise any concern. She just said, I cannot do this because I have perhaps a conflict of interest.
Okay.
And I assume that, she was a private attorney as well as being the district court judge, that she may have had some matter that she was representing some of the parties that would have been involved. And so I didn't question her.
Yeah. I want to bring to the attention of everyone who's participating in this webinar that at the screen below, or at the bottom of the screen, you have a place that says chat, that if you do have questions, to go ahead and type them in at any time. And I'll go to Kimberly at this point to ask if there are other questions that have come in at this point.
We have a question that might be a little bit premature, and it's, what are the chances that this will happen again?
Well, have you been watching what's going on in the federal forums lately? It's remarkably similar to what occurred, which I thought would never occur at the Cherokee Nation. The pushback on law enforcement overall at the beginning, the edging up to define lawful responsibility of federal agencies and so on and so forth. It's remarkably similar to what happened at the Cherokee Nation. Of course, a lot of other things have to happen and hopefully don't at the federal level.
Yeah. Okay, let's go to the next slide then. And this is everything that happens in the next month. This is just stunning to watch this all sort of unfold so quickly. And Pat, rather than read, me read through this, or Pat and Paula, both of you, you go ahead and take a look at this and just jump in and what you remember about this, what details you can add.
Well, your bullet points are right on the mark, Julia. I don't have any issue with any of them. On a personal note, I'm speaking for a lot of people that were involved in this, directly involved, is that all of us were remarkably surprised when something like this would happen, when Chief Byrd attempted to disband the Marshal Service. The most common expression, he can't do that, and then he would do it. When he defied the court's order, we would say, he can't do that. That's against the rule of law. That's unconstitutional. And he would do that. When he said, I was attending a tribal council meeting during those tense times, and the chief said that he called the FBI in. Well, that was a lie. I called the FBI early on and asked very aggressively for them to come in and examine what we were doing at the Marshal Service and conduct their own investigation. Um, what one of the personal critical moments for the Marshals was on March 4th, late in the afternoon on March 4th. Our power was cut off in the building that we occupied, and our phone service was cut off. And we were under, because we had had some back and forth, and I was involved in the back and forth with the administration response and the press's investigation of it independently and so on and so forth. And Judge King, or Justice King, had ordered a gag order, so none of us were supposed to be talking about it, which we in the Marshal Service obeyed, and Diane Hammonds obeyed religiously. And Chief Byrd had a meeting, I'm thinking up in Veneta, a tribal meeting, and he broke the gag order that night. And
Prior, as in prior.
no, that was Judge Birdwell was in
Okay,
prior.
okay.
At any rate, there was a number of meetings going on. I drove to Prior to try to meet with Justice Birdwell to get his guidance. But by 10 o'clock that night, I decided that the Marshal Service was in danger of being overtaken. And so we abandoned our building, and the evidence that we had taken in as a result of the investigation, we boxed that up, and with the permission of the court, we moved to the courthouse. And after that, the long siege of the courthouse began. We occupied the courthouse 24/7 from that day on until the unlawful June takeover by the burglars.
And I've always been kind of amused by I think it was the FBI's response to the claims by Chief Byrd that he had been wiretapped. They listened to the tape, apparently, that he had provided them, and they said all they heard were a bunch of people complaining about how the chief had violated the Constitution. It didn't meet the level of a conspiracy, as he was
Right.
claiming.
One of the similarities is what's going on now at the federal level, that the people that are complaining, the administration turns around and say that's their complaint, which is totally illogical.
Okay, let's go to the next slide. And this is just kind of what I wanted to do was give people a sense of the lawsuits that were flying around at this, because boy, they really started to snowball as well. So in 1 month, these are the lawsuits that begin to be filed. So we've got contempt charges against Bob Powell, who is the tribal inspector, I think that you were mentioning a moment ago. That was his name. He was non-Indian. So we have that. The chief of staff and the secretary treasurer of the Cherokee Nation are charged with contempt because they were, what was it, Pat? They were supposed to reinstate the pay, wasn't it, to the marshals, I think?
That's correct, as well as a report to the court on the expenditure of funds. And they were held in contempt, and they were ordered to be, they were in civil discontempt, I might add, and Justice King and the court ordered them to be arrested.
Yeah. And then we've got the Cherokee County District Attorney, who was a Cherokee Nation citizen, Diane Barker Harold, and she decided to invalidate all of the Cherokee Nation marshals' cross-deputization agreements with the county law enforcement locally. And then Diane Blaylock files a complaint against the chief for obstruction of justice. And so we've got all of these things that are now beginning to pile on as legal actions.
Yeah, let me just add to the invalidation, or the purported invalidation, which was not legal, of the marshals' cross deputation agreements. Diane Baker Harold subscribed to a theory that the marshals and law enforcement was subservient to the person in power, not to the law. And the Attorney General, sometime afterward, held that to be wrong. But that was one of the theories of that district attorney's office, and the Byrd administration was on the theory that the Cherokee Nation chief was sovereign over everything, and that he could not violate the law, which you hear some arguments being made now by the presidential administration that are somewhat similar.
Okay, let's go to the next slide. And the big event here, I think, is occurs with the tribal council. So Paula, do you want to talk about that a little bit, this meeting that they had? 9 of them at least. And
Yes, of course, you pointed out in the beginning, it takes 2/3 to have a council meeting and to conduct any business of the nation. They decided, since we weren't cooperating with them, or they didn't have a majority that would rule in their favor, they decided that they would just conduct their own meetings without us. So 9 of them got together, which didn't give them 2/3 to conduct any business, and they decided to get together to pass laws that they could rule the nation, I guess, without a majority.
They in fact
Held private meetings, secret meetings.
they in fact, the administration hired a notable attorney out of Oklahoma City
What was his name?
who had a connection. He was a spouse of one of the federal justices from the 10th Circuit Court of Appeals. Fairly notable attorney, high priced. He had written an opinion that worked around the constitutional requirement that 2/3 of majority didn't necessarily equal 10. And Jiggs Phillips,
Harold Phillips.
who I never will forget, I was at the council meeting when he confronted the other council members and this notable attorney by saying, you know, I'm an old school teacher, and I remember from grade school that 2/3 of 15 equals 10, not 9. And he prevailed.
Yeah, the 9 were having secret meetings and trying to change laws that they could do it with a simple majority. Because their goal was, of course, to remove the justices that was ruling against the administration for their actions to, fire the marshals, etc. Basically, they just thought they were above the law, so they were creating their own laws.
And that sets up the impeachment proceedings.
Right.
Bogus impeachment.
They were trying to set up to impeach the judicial branch.
right. And it should be said probably that Jiggs Phillips is one of these 9, correct? Even though he isn't generally considered to be in that camp, so to speak, but he did not take the action of boycotting tribal council meetings as 6 other counselors, including you, Paula, did at some point. And so I'm not exactly clear about when or even if you all, the 6, decided at some point to sort of deliberately begin a boycott in order that there not ever be a quorum to conduct business, or was this simply a matter of a boycott kind of just being imposed because you weren't being invited to these meetings?
And first, they did have a secret meeting deciding that they wanted to change the law so that a simple majority could change law for them so that they could set up the impeachment. The private meeting did not take, of course, and of course they eventually had to, go in public and have a meeting, call a meeting, post a meeting, all the regulations to be followed in order for it to be legitimate. So at that point, we knew if we showed up that we would begin the impeachment process, because if one more of us had showed up at a council meeting, they would have had their 2/3 to vote. Didn't matter how we voted, they would have had, the 2/3 to call a legitimate meeting.
Councilman Phillips was always a swing vote.
Like,
But when it came down to who could be counted to uphold the Constitution, Jiggs Phillips stood up and he walked out of the impeachment proceedings, which made their meeting invalid.
Mr. Phillips he disagreed with the boycotting, but it also allowed him to be the media, the go-between, and he could visit with both sides, and he was the negotiator, etc. They would propose something, he would bring it to us back and forth. We adamantly opposed the impeachment of the justices, starting that process, and so the only tool that we had as a minority was to not show. So yes, we chose to boycott. We had 6 that agreed to it. Jiggs, like I say, stayed in the middle of it, but we used him as a mediator, so to speak.
And had Jiggs not walked out of the impeachment proceeding, they could have made a strong argument that the justices had been removed. But by the way, the Cherokee Nation hired Gene Stipe as the prosecutor at the impeachment.
I forgot about him.
If anybody knows who Gene Stipe was, that was the cherry on top of the sundae.
Yeah, he went to prison himself at some point, didn't he?
That's right.
Shortly after that.
Okay, and then they recess this illegal meeting and they pick it up again later in the month. And at that meeting, protesters know about it, I guess, and they're forcibly removed by Bird's security force. Now, was this the meeting that I always hear about, at which the dangerous women, Marion Hagerstrand, and so forth, were removed from it? And actually, Ralph Keene, Chief Justice Ralph Keene, also was this the one that he was?
No, the justice did not go. That was the impeachment proceeding. There was another event later on, but that was the impeachment proceeding where protesters, and I was there, not protesting, but being there as a marshal, were kicked out of the meeting. This was the one where Gene Stipe presented a Sears catalog full of evidence against the 3 justices, and they voted to impeach the justice unanimously, but they did not have a quorum, claiming that under this bizarre legal theory that they did constitute a quorum, which the JT later ruled that what they did was illegal, that they could not impeach the justices in that kind of fashion.
I think the meeting that you're referring to, Julia, was later on in the summer. The administration at a certain point, after the attempt to do away with the Justice Department or branch, they locked the doors and would not let people come into their meetings. When they had meetings, the 9 would have meetings on different things and what have you. They literally locked the doors and folks had to stand outside and they wouldn't let them in. So then they finally decided that they would let them in. They let them in a side door into the council meeting instead of in the front door. And that's when Marion got exited from the meeting. She stood up and said a few things, and they just took her out.
This is a time when you literally could see the Cherokee Nation governing system starting to crumble
Right.
in its foundation,
And we should,
the wall was broken down.
and we should say for those who don't know that Marion Hagerstrand, she was a really tiny, elderly lady who was from a very prominent family in the Cherokee Nation, and she was a powerful force despite her size and her gender and everything else. But they none of that mattered. They just took her out of there.
Right.
She served in the Philippines as an Army officer nurse during
Yep.
World War II. That's where she met her husband, who was also an Army, who was also an officer in the Army, Marty Hagerstrand, who was also a great person who passed away during this same time frame.
Yeah. Let's go to the next slide. And unfortunately, we are running really, really late here, but we'll try and move through this as much as we can. So here are the 9 and the 6, right? And I just wanted to give the names. Our present principal chief, Bill John Baker, was one of the people who was part of the 9. Our present director of education and chief of staff, Chuck Hopkins Sr., was one of the 9. So you'll see some familiar names there. As part of the 6, Troy Wayne Poteet served as our Chief Justice of the Supreme Court for a couple of years and served 10 years on that Supreme Court. So you see some pretty well-known names of people who continue to be in the thick of things. The next slide. And again, these were just the legal actions. So now we've got complaints of diversion of funds without tribal. And Paula, you were the named plaintiff, although you were joined by many others in an action that was filed the very evening of the first illegal meeting of the 9. Correct?
Correct. There were many things happening all at the same time, so many wrongs that you just couldn't get your arms around it. As a legislator and the responsibility of the finances of the nation, and we didn't have a clue. As a legislative body, we had constitutional duty and responsibility, but we had no information and did not have a clue of where the money was, how much we had, where it was going. It was just going. We could see it walking out the doors, but no accountability for it whatsoever. So what we did was just narrow our focus to the attorneys. So we pulled agreements, contracts, etc. And that's where we discovered that we were overpaying the attorneys pursuant to any contracts or agreements that they had in place. Thus the filing of all the $65,000 and all the plaintiffs getting behind that suit.
And
It was pardoned other than Bird.
And we have a question that has come in that is, the question is who was pardoned other than Bird? I'm not sure that there was ever a pardon of Bird. He was never charged under, was he?
He was charged and arrest warrants were issued by the court for obstruction of justice and other matters, which the Cherokee Nation Marshals, which were not being paid, and we were at odds with the Bird security force. We never served the arrest warrant. Things as you go on through your presentation, you will follow what happens. That gets
Yeah.
kind of put on hold for a while. But the answer to the question is Byrd was charged but was never tried. And at the conclusion of the election where Chad Smith won the election, I recall very vividly a discussion that Chad Smith, Julian Fight, the general counsel, and I had about whether or not to proceed after the election with a hearing on those charges of former Chief Byrd. And it was decided, and I agreed with the decision, that there had been so much discourse and so many things going on at the time. It was a time for the nation to heal, and that we did not need to recount all of these things that had occurred over the last 3 years. And so he was not prosecuted. So he wasn't prosecuted, but he was never pardoned.
Wasn't the deputy part of that charge?
No,
Garland?
no, I don't think so. He may have been in a contempt part of it because he was acting chairman of the tribal
Okay.
council. But
Okay.
no, he was not prosecuted and was not pardoned.
Let's go to the next slide. And okay. So if they can't make a constitutional change, the 9 decided to change a statute. I mean, the Constitution says 2/3 to conduct business. So they're going to, what was this? They were going to pass a statute that would make a simple majority enough to do council business, but you can't pass a statute that is in conflict with the Constitution, according to the Constitution.
There were several pages of legal theory that said that was what you just said was wrong. It didn't make sense.
Okay.
It had made common sense of it, but that's what they were writing on.
And they also are going to create a court of removal, which also, is going to give new powers to the tribal council that are beyond what is demonstrated in the Constitution as well. So we've got all of these kinds of things. And the justices refuse to acknowledge that they've been impeached, and Byrd cuts off their pay at this point. So any recollections about this month? We go month by month.
It was an eventful.
It was very eventful.
It was eventful and very dramatic. I remember people that subscribed to the Tulsa World maybe remember Rob Martindale, who was a longtime reporter, and I was being interviewed outside the tribal complex at the end of the so-called impeachment hearing. And he asked me what I thought about it, and I saw Gene Stipe striding across the walkway, and I said, well, look who they got as prosecutor. And I said, look up at the flagpole. Thank God the American flag and the Cherokee flag are not flying here today. It was on a Saturday, so somebody had neglected to put the flag up. But it was a shameful day for the Cherokee Nation.
It was. It's unbelievable. It was just unbelievable. And to break this down into months is just kind of mind-boggling for me, because it was one continuous. I mean, it was almost as you were on call day and night, 24/7.
Destruction of documents, shredding documents.
It just didn't end. It did not end.
People being fired at the Cherokee Nation without cause. It was very dramatic.
It was.
We have a question that's come in that goes back to your mention of the conversation about whether to continue with the charges against Chief Byrd. The question is, do you regret that decision at this time? I mean, I understand, Pat, that was not your decision to make, but do you think that it was do you still think that it was the right decision, I guess, would be the question.
In retrospect, I think it was the right decision. None of us ever dreamed that there would be a comeback for these folks that were involved in trying to destroy the Cherokee Nation. But I mean, only history will tell. You know, no one could predict what kind of disorder it would have caused to continue to try to seek justice over these matters. I mean, we won because we won the election and restored order to the Cherokee Nation, and that's how most of us felt, and that withstood 12 years of time. So, you know, I don't, from time to time, you know, I say, you know, you remember when we talked about whether or not to prosecute? But no, I don't regret it, and I probably was at the end of the stick of most of those direct abuses of the previous administration.
Okay, let's go to the next slide. And then we have, okay, so the marshals, these were the legal actions of this month, filing suit against the BIA for interference. And I guess, Pat, this was because of the retroceding of law enforcement back to the BIA. So now the BIA police were beginning to enact law enforcement functions within the Cherokee Nation. Is that?
That's correct. And you know, we all thought it was a long shot. I mean, what the court ruled, and you know, the court did not want to get stuck in the tar baby of the turmoil going on at the Cherokee Nation. So our suit was dismissed for, quote, lack of standing, which meant that the marshals did not have the standing to contest a decision of the executive branch of the Cherokee Nation.
And we have a photo here of the justices, the three justices of the Cherokee Judicial Appeals Tribunal. And then the gentleman second from the left that they're standing with is the U.S. Supreme Court Chief Justice at that time, who was William Rehnquist. And I'm sure it was an honor for the justices to meet Justice Rehnquist, but we also need to note that Justice Rehnquist and the Rehnquist Court, as it was called, is generally viewed as being very hostile to Indian sovereignty and Indian issues. So,
Julia, that it didn't probably get as much publicity as the Marshals lawsuit in federal court in the Eastern District, but the justices also filed a lawsuit in the District of Columbia, and it was dismissed as well and I think the reason was lack of standing as well, because it was perceived to be an internal tribal dispute, and that the court didn't necessarily have jurisdiction over it.
Okay, let's go to the next slide and try and move through the next 2 or 3 months here quickly. So you talked, Pat, about the marshals basically occupying the courthouse 24/7. But on an early morning in June of 1997, Byrd's security forces, and this was a raid, I think, they took over the courthouse and locked everybody out.
That's true. It was a very hot day. I got a call about 4 o'clock in the morning from Sharon Wright, who was the second in command, and she told me that the courthouse had been invaded by the security force, that we still had marshals inside that were resisting, and she asked for my advice, and I told everybody to stay in place, and immediately got cleaned up, got in the car, and went to Tahlequah. And when I got there, there was this huge crowd surrounding the courthouse of mostly Cherokee citizens. The county law enforcement department and the BIA law enforcement department and a ton of state law enforcement officers were out on the courthouse lawn, barring any of the citizens to come on the lawn of the courthouse. I was still the marshal, so I walked onto the courthouse grounds and talked privately to Sharon, who was inside the courthouse. And I decided that it was such a volatile situation that we would allow them to take over the courthouse after we had all of our evidence and all of our weapons removed and put into the safekeeping of the FBI. The U.S. Attorney's Office was there. Linda Epperly was there that day, a great friend of the Cherokee Nation. She was an assistant U.S. attorney and still is, as a matter of fact. And everything ended peacefully. My friend Chad Smith was arrested that day. I watched him being taken down. I was on the lawn, and he said something like, "Whose courthouse is this?" And pulled up the yellow tape and started marching towards the courthouse, and the crowd was following him. And he was taken down by a federal officer and a county officer who later tried to charge him or alleged that he had assaulted them, which he did not. But nonetheless, he was arrested and incarcerated in the county jail until he could be released on his own recognizance. Or I can't remember if he was bonded out or not. I think Julian Fite, our friend and attorney,
We had Chiefs Mankiller and Swimmer, and they were on the phones, and they were saying they can't stop you from going to the courthouse. They can't stop you. You can go. So we all did go. Didn't turn out so well.
Yeah. It was a very emotional day.
It was.
And I would not have done it differently because there was just such a danger of people getting hurt that I didn't think it was worth it. And so we abandoned the courthouse, and they took it. The burglars, as Diane Hammond said, the burglars took over the courthouse for a period of time.
Yeah.
Okay, let's go to the next slide. And so there, as you've already mentioned, Pat, the suit against the BIA was dismissed. And also, as you've mentioned, now the Oklahoma Attorney General overturns the district attorney's invalidation and says that the cross-deputization agreements with the Cherokee Nation are still in place. They're still good.
You know, the cross-deputation is between two governments. It's not between two individuals, which evolved out of the theory of the sovereign king of the Cherokee Nation and the local DA, who shortly thereafter got unelected to the office that she held.
Let's go to the next one. So, and I'm wondering what took so long for this to happen. Finally, the Diane Blaylock Hammonds was finally fired by Chief Byrd. Yeah, she was allowed to hang around a lot longer than many other people were. Justice Birdwell had a Purple Heart and other service medals, and he was not allowed to retrieve them from his office. He finally did get them back, but they had been deliberately damaged.
I think, if my memory serves me, he had a Silver Star.
The Silver Star, wasn't it? Yeah.
Right up there, close to the Medal of Honor. When you say defiled, and I won't say it here, they were mutilated and disgraced. I mean, I could not believe what they did. And immediately thereafter, after they took took over the courthouse, they and their attorney, Diane Substitute, who supervised it, started to destroy documents that we had, evidentiary documents that we had at the courthouse. Unbeknownst to them, Sharon had already made copies of them and had put them away in safekeeping. Terrible day.
And what I read was that even among the 9 counselors who were supporting the Byrd administration, even a couple of them were so disgusted by the way that Justice Birdwell's medals had been treated that they actually walked out of a meeting where it was announced that this had happened. If my reading is memory is correct. Yeah.
I don't recall that.
Yeah.
Yeah.
But anyway, the public affairs.
I will just go tell you, I'll go ahead and tell you how bad it was. They defecated on his medals.
Yep.
In the courthouse.
Yep. The Cherokee Phoenix was under the Public Affairs Office at this time, is that correct?
I think so.
Yeah.
And it was because we did not have a Free Press Act at that point, and
No, we did
Yeah.
not.
and Dan Agent, who put together the timeline of these events, all of the employees except for the basically the secretary, I guess, of the office were fired.
Yeah, the Cherokee Nation newspaper became a propaganda rag at that point in time.
Yeah.
After Dan, and I mean, there was pressure on Dan and other employees of the Cherokee Nation's newspaper, but at one point when they were gone, it completely turned over to a propaganda rag for the administration.
Okay, let's go to the next slide. And so here we begin to have a lot of things rolling quickly once more. The justices are out of their offices, but they're still functioning as a court, and so they continue to issue orders, and Chief Byrd is continuing to add to his private security force. The United States says they recognize the JAT, but they will not recognize either the marshals or Byrd's force. They still say that the BIA police have authority at this particular moment. And so when you and the marshals attempt to retake the courthouse, the BIA police basically and state law enforcement turn you back, huh? Is that how it goes?
Yeah, that's true. I had been in constant contact with the United States Attorney for the Eastern District, who had tried at some point to mediate in some fashion to heal the crisis, which he was not successful doing. And the our annual tribal homecoming was coming up, and the JAT had the what's known as Cherokee Nation holiday, ordered that the marshals retake the courthouse in as civil fashion as we possibly could, because the JAT had exclusive jurisdiction over the courthouse and the land surrounding it. And so we attempted to carry out that order, and were resisted by a whole bunch of law enforcement people from the county and the state of Oklahoma, and so we were unsuccessful. In fact, I was arrested. I was never charged, but I was arrested and spent a day in the Cherokee County Hotel in Tahlequah. But
when you guys attempted to take over, a lot of citizens were right behind them and pushing, trying to open
Yeah.
that door and
That event got the attention, and that was not really what was intended, but that event got the attention of the federal government. And at that point in time, the Attorney General, Janet Reno, and the Secretary of the Interior, Bruce Babbitt, intervened and called for a meeting, which I think is going to come up in some of your next slides.
Yeah, so finally they realized that this really was actually extremely serious, what was going on down in Oklahoma here. But I always remember Chief Smith later talking about, with a real sense of just fury, about the statement that the district attorney had made, that the reason that state and local law enforcement could come onto the courthouse was because the courthouse was not deemed Indian country under the legal definition of that term, and that was just preposterous. And what, you know, he even likened it to being treasonous for a Cherokee Nation citizen in the DA's office to basically, as he saw it, sell out, you know, the sovereign and the tribal jurisdiction of our very own courthouse, our historic property.
Right. What was even more treasonous, Julia, was the leadership of the government of the Cherokee Nation agreeing with the state government that they had jurisdiction.
Yep, let's go to the next. Still in August, right? So now we have lawsuits that are filed against the district attorney and state officials. The chief said he should be able to hire and fire at will to ensure loyalty to him. And I think, boy, you talk about some comparable statements recently in the federal administration, you know, that one really rang, you know, similar to me. And as you've already stated, hundreds of employees were fired during this administration.
Yeah.
And so the next bullet here is what you're talking about, Pat, right? That finally the federal government sort of snaps to it that this is really very serious, and that they begin to intervene and try to negotiate, you know, some kind of agreement between the various groups within the Cherokee Nation that are kind of, you know, trying to hash this out.
That's correct, Julia. And your second bullet on the August of 1997 is really on point when you say, you echo the statement that Chief Byrd made at the time, that he should be able to hire and fire at will to ensure the loyalty to him. That is when he was directly running against the Constitution of the Cherokee Nation. And where I hear similar words being uttered at the federal level now, I think, my God, I could not have believed that this would have happened again, particularly at the highest levels of the government of the United States of America. So what actually occurred is that Janet Reno, the Attorney General of the United States, and this is unheard of for them to be involved in this type of dispute, and the Secretary of Interior called a mandatory meeting in Washington, D.C., and called officials of the administration, including Joe Byrd and his attorney and others, along with former Chief Ross Swimmer, and I think Chief Mankiller was invited, but she was ill and couldn't go. And so they met all day at the Interior Department, and Chief Byrd at the last minute, or not the last minute, or decided he could not agree to allow the court to come back in session and recognize him, and left the building. And shortly thereafter, he was informed that, the president has special authority to fire the principal chief of the Cherokee Nation as he sees fit. And Chief Byrd came back to Washington and agreed to allow the courthouse to be reopened and the justices to resume their duties. So that was a clear victory for the Cherokee Nation and the people that were involved in this all this turmoil and trying to uphold the Constitution and laws of the Cherokee Nation.
And if we can go to the next slide. The independent report, this had been implemented several months earlier, actually, and it was called the Masad report. It was non-Indian people, who were sort of observing this or looking at the situation from the outside. And they released their report this month also, and, sort of an impartial perspective on the whole thing. They agreed that, among other things, that the impeachment attempt of the judicial branch by the executive branch was not constitutional. And so they gave that support to all of the folks who had been saying this all along, the 6 counselors and, many other people as well. The courthouse reopened, but for the stated reasons that he feared for his safety, I guess, as I understood it, that Chief Byrd didn't participate in the parade, did not give the State of the Nation address that year. And apparently the BIA had safety concerns as well, because many people remember that year they were on the rooftops, fully armed throughout the entire parade.
They actually, it was actually the state people that had snipers from the special operations teams on top of the downtown roofs during the event. We didn't have a parade that year. There were some people that marched anyway, but the principal chief did not address the crowd, nor did they have the traditional parade that year because of the concerns for public safety. And the city of Tahlequah was armed up like a South American camp with people up on top, law enforcement personnel up on the roofs with sniper rifles and binoculars and so forth. There wasn't any turmoil on the streets that day. I mean, I was there and Paula was there, as well as a lot of loyal Cherokees, including Chief Wilma Mankiller, but who showed up, and we had a visit in spite of the lack of the presence of the traditional chief and the governing body of the Cherokee Nation.
Okay, let's go to the next slide. And so even though we apparently have an agreement in place at this point where the JAT will be reinstated, the Marshal Service will be reinstated, September comes and goes, and still half of the Marshal Service officers have not been reinstated back to work. Files have not been returned. China Glory Jordan is still operating under the executive branch. The BIA is still enacting the law enforcement. Legal issues outstanding. And then there is an audit that comes in at this point, and the auditors, and this is a well-known accounting firm, right? And they say that the accounting controls of the Cherokee Nation were horrible. In fact, they said they were as serious as it gets.
Yeah.
So
the interesting thing that happened, which is atypical for the Cherokee Nation going as far back as you want to go back, is during the 4 years of that administration, an unqualified audit was never issued. All of the audits that were held were qualified. For people who are not familiar with auditing procedures, it means that they cannot, the independent auditors cannot make sense of your books. That either the record keeping is so sloppy that it doesn't make sense, or they are being intentionally covered up so that you can't track how money is being spent.
So at this point, yeah, no, let's go to the next slide. At this point, this is where the timeline that Dan Agent had put together ends. And my sense of things is that it just kind of stayed in a holding pattern for the next couple of years until 1999. And as you said, a new administration comes in. Paula, the 6 counselors continued to boycott during those next years, or?
We would always negotiate what issues would be considered and would show for certain matters. One example, to pay the marshals, we showed up for that one, made a quorum. Other issues, I can't think off the top of my head some of the other issues, but there were issues, things that needed to be passed, budgets needed to be passed, you know, expenditures to carry on business, day-to-day operations. We would negotiate what was on the agenda and would show up for those things. Other than that, yes, it was just touch and go, and it was just, you know, there was no trust between the branches of government.
It was sort of a partial truce.
Right.
And once we thought that the crisis was subsiding and things might start getting back to normal, a faction of the tribal council led by Bill John Baker would stir it up and try to start something over again. And then the council members that had been loyal to the rule of law would not participate in those meetings when they did that. And so things just kind of stood at a partial truce until we could have an election, which ultimately decided to,
Right.
that the crisis would end.
There were so many things that they would try, and so that's you know, when we did meet as a legislative body, it would be an agreed upon agenda before we walked in, and if anything come up prior, you know, during the meeting, we would have, you know, we'd have to get up and walk out, so the quorum they wouldn't have a quorum.
Yeah, Barbara Starr Scott made a statement that I think was true, and she said that I never would have dreamed, and she was a longstanding politician of the Cherokee Nation. She said, I never would have dreamed that to hold the Constitution of the Cherokee Nation, I would have to absent myself from tribal council meetings. It is unbelievable.
Right. They were trying to give the courts back to turn them into a CFR court. It was just incredible, some of the things that they were proposing.
I think to this day, if people are familiar with the 638 contracts, these are basically the contracts that tribes enter into with the federal government to run their own affairs, essentially. And the Cherokee Nation contracts everything, everything that we possibly can, including law enforcement. And the one time it was brought up when I was serving on the council, just a historical point, the one time in our history that we have actually retroceded our contract back to the United States was in this era, and it was retroceding law enforcement back.
Right.
And that's just, you know, as a tribal government, you never want to do that. You
Absolutely.
never, ever want to relinquish any degree of sovereignty back to the United States, but that is exactly what happened at this moment. Yeah.
Right. Sad day.
Sad day. Let's go to the next one. So this is just, and the one thing I want to say is that just to plug our next webinar, which will be on March 29th, the Constitutional Convention that took place in that year was rather amazing. And so it comes out of all of this turmoil of these years. So Joe Bird, our former chief, is presently serving on our tribal council. He ran for tribal council in 2011. I had one concurrent term with him, and then I termed out, and then he was reelected. So he's currently serving his second term, and he is today the speaker of the tribal council. Diane Hammond served 6 years under the Chad Smith administration as the first female general counsel, and then as the attorney general, and also the first attorney general of, under that title of the Cherokee Nation. She's now a professor of criminal justice at NSU. Go to the next slide. So the boycotting counselors, I put up 6 names before. So Paula, you want to talk about yourself?
Well, I ended up marrying Pat Ragsdale.
That came later.
and I served in the Smith administration, worked in DC and the government relations, etc., until the election of Bill John Baker. So I'm now working for the state of Oklahoma.
Our loss. Yep.
I worked for Chad for the first 4 years, first 5 years of his term. And ironically, I was offered a job to go back and work for the special trustee for the Department of Interior, which I did for a year. And then the irony of all ironies, I was appointed the director of the Bureau of Indian Affairs. And subsequent to that, I became the director of the Bureau of Indian Affairs Law Enforcement. So who would have ever thought it? Particularly in those turbulent days that we've been talking about.
And Troy Wayne, who many people know, was appointed and confirmed to the Cherokee Nation Supreme Court, which is what the Judicial Appeals Tribunal became known as after the 1999 Constitution was adopted. So he served 10 years there. He was its Chief Justice for a couple of years. His term ended in 2017, and he was not reappointed by Principal Chief Baker. And I don't think that surprised anyone, including Troy Wayne.
He seen him today, and that was what Pat said to him. Pat said, "Well, I was surprised they didn't reappoint you."
So of the 9, the counselors that were supporting the Byrd administration, Bill John Baker continued to serve on the tribal council until his election as principal chief in 2011. So he's now in his 2nd term as principal chief, and there's been a recent ruling by the Attorney General of the Cherokee Nation that he can run for a 3rd term in 2019 if he wants to. Now, we've got term limits, but as many people will recall, in 2011, we had to do a redo of the principal chief's race because it was so close that they couldn't, the court could not decide within a mathematical certainty who had won that election. So as a result of that, he did not get sworn into Baker did not get sworn into his term until early October, which is about 6 weeks after the term would have started. So because his first term lacked about 6 weeks of being a full 4 years, the present Attorney General has ruled that he can run for a 3rd term rather than be termed out in 2019. So we'll see if he does that or not. He has publicly stated, I think, that he's not going to, but who knows?
I don't know that the court has confirmed that the Attorney General's ruling on that is the last ruling to be said. I don't know that there has been a fighting in the court.
Yeah.
I doubt that. I totally disagree with the Attorney General's opinion that because the current chief served 1 or 2 weeks less than the full term, that he's eligible for a 3rd term.
Yeah.
I don't think that was the intent of the Constitutional Convention.
No. And I think that I looked at the Constitution and I don't see it addressed in there, but I'm remembering something that we had statutes, at least, about terms of counselors. And if I forget what it was, but it was they were addressing at least the serving of only portions of terms and how it would be handled. But we have a question that's come up that says, doesn't the Cherokee Nation Constitution only speak of 2 elections and not 2 terms in reference to the principal chief? And that's an interesting question. I don't know off the top of my head. Do either of you know?
I think the answer is yes, it's 2 elections, not 2
Yeah,
terms.
yeah.
I mean, it hadn't been argued in court, so that would be an ultimate decider of the issue, but you'd have to have standing, I suppose, to
Yeah.
file for it, meaning to have standing, you'd have to be a candidate for that position, or conjure up some other legal theory that would give you standing.
So we won't know until late this year, I think, and if Chief Baker is going to run again or not. And if he does, then I would imagine this question will most definitely come to the court. There are other counselors who supported Byrd, and Chuck Hoskins Sr. was one of them. He serves as a Democrat in the Oklahoma State Legislature right now. But he also serves 2 concurrent roles with the Cherokee Nation as the Director of Education. He still is Chief of Staff as well, is he not? Or
My understanding he is.
yeah, I didn't think they'd appointed anyone else. So,
No.
and then his son, who is Chuck Hoskins Jr., is currently the Secretary of State of the Cherokee Nation. So keeping it all in the family. So here you are, Pat, and and I've got some things wrong. I had thought this was an interim position. The Assistant Secretary of the Bureau of Indian Affairs is the Director of Indian Affairs, correct? It's the same role, but and then you were the director.
An interim, but that is the Director of Operations. The Assistant Secretary is overall in charge of Indian Affairs.
Okay, okay. And then I, best remember interacting with you very directly as the Director of Government Relations under Chad Smith, under that administration. So, and doing a very good job indeed. And then, of course, Chad ran for principal chief and was elected and served 3 terms because we did not have term limits the first time that he ran. So you can't apply a constitutional change retroactively. But then, as we know, was defeated in 2011 by Bill John Baker. So, and again in 2015, actually, by Bill John Baker as well. Go ahead. Next. So Diane Barker Harold served 8 years as the Cherokee County District Attorney. And then I remember that she was also hired as the Tribal Council Attorney in my second term. And I think was there only 1 year or 1 term or maybe 6 years, something like that. She's on the board of directors for the National Crime Victim Institute, according to the web right now. Her daughter, however, as we remember, serves on the Cherokee Nation Supreme Court, appointed in 2013 by Chief Baker, which means that her daughter, Angela Jones, was serving on the court at the time when her mother was the tribal council attorney and would conceivably have been arguing cases in front of her daughter. So again, keeping it all in the family.
Well,
No nepotism there.
Nope.
and her
And
husband works at the hospital.
okay, okay. And Tina Glory Jordan served on the tribal council. She served 2 concurrent terms with me. So she was on and she was the speaker of the council in her second term. She's presently the attorney for the Cherokee Nation Gaming Commission. Is that correct?
I think so.
Yeah. So that's it. And if we go next slide, and we are finally finished. And thank you all for being so patient. This was a very complex time in our history, but many, many constitutional issues came up. And so our next webinar, which will be on a Thursday night this next time, March 29th, we'll try to keep it from 8 to 9 again. This one will be hosted by Jay Hanna, and he was the commissioner of the Cherokee Constitutional Commission and led the Cherokee Constitutional Convention through 9 amazing days. And I hope that you will all join us again. We'll see what the reaction to the 77 Constitution was and the many actions that were taken to shore up our new document so that hopefully even better procedures are in place for us in case anything like this happens ever again. And Pat and Paula, I'm so grateful to you for being with us tonight. You guys have just added so many wonderful dimensions to this whole historical era, and it's just been really invaluable. So thank you, thank you, thank you.
Julia, just let me add, the lessons from the Cherokee Nation constitutional crisis was, number one, our government held under the most strenuous attack in modern history. But more than that, it held because the citizens came to the aid of the Cherokee Nation. It wasn't just the principles that we talked about. It was the common everyday folk that came to the aid of the Cherokee Nation that sustained the marshals when they weren't getting paid and bought us food and fixed us meals and demanded accountability. And we survived that. And that's the lesson. If people don't come to the aid of their governments will not survive.
Right.
And that is a powerful, powerful message to end on this evening. So we will all take that to heart. Thank you so much.
Thank you.
Thank you, everyone. Good to see you.
Thank you for joining us. We would like to give a special thank you to Pat and Paula Ragsdale, as well as Dr. Julia Coates. You can access a recorded version of tonight's presentation at cherokeepens.org or at staruniversity.org.